Hi viewers, welcome to the second episode of our Tech Prosecutor new podcast series. I'm your host, Mohammad Bakhtiar, and here we are today with Janvi ma'am. Very warm welcome, ma'am, and thank you for taking time out of your busy schedule.
Not a problem. I would request you to call me just Janvi. And thank you so much for having me. I am glad that you guys are doing such, taking such an initiative, specifically in this field, which is quite different from the mainstream law. And I believe it's very important given the omnipresent um, nature of technology around us and the way it is integrating with law. So, yeah, I'm really looking forward to this podcast.
Thank you so much, Janvi D. I'll say D. It's better. So, uh, so just to give our viewers a brief introduction about ma'am, Janvi D. Janvi D has recently done her law degree from Jamia Millia Islamia in 2024 and has ever since been working as an able data protection consultant. She has been working on privacy laws, telecom and media laws, and has also been handling data compliance for data fiduciary under different jurisdictions. So to begin with, without any further ado, I would like to start off, ma'am, with a very basic question, which would set off the stage for today's podcast discussion. So, if you can just explain to our viewers that what all does data compliance, data protection compliance encompasses, and what all steps have to be followed.
Okay. Uh, so to begin with, I'll say that the actual implementation and the practical aspect of data protection and privacy is very different uh, from the things that we read in the laws and all. So it's quite different. So let's start from, let's take an example of an end-to-end privacy implementation for any organization. So, first step, primarily, we need to understand the jurisdiction in which that data fiduciary, or let's call it an organization because it could be data fiduciary or a data processor. So that is operating. All right. So when we understand the jurisdictions in which it would be operating, then we'll get to know about the applicable laws, right? So
Yeah.
from there, we'll create a privacy control framework where we'll jot down all the laws that would be applicable to that particular organization. Then second step is to conduct a gap assessment. So basically, a gap assessment is a procedure in which we try to understand the gap that is there in the organization, as in the steps that the organization is already taking and the steps that are required under specific legislation. So we try to we try to figure out that gap, and then we'll prepare records of processing activities. That's the short form is ROPA. It's
Yeah.
defined under Article 30 of the GDPR. So basically, what is a ROPA? ROPA is a document where we try to figure out the life cycle of data. We try to mention the personal data attributes that a particular organization is collecting, the legal basis of processing those personal data attributes, then the purpose, then the category of personal data, whether sensitive data or general data. Though I would like to mention that in under our DPDP Act, we have not classified the data as sensitive or a special category of data, but we do have SPDI rules which talks about sensitive data, right? Then the source of collection, if there is any cross border transfer, third party transfer, we try to figure out that. So what would be the end result of preparing a ROPA? It would be we'll have a personal data inventory in place, so we'll know what total amount of data we are collecting, processing, and everything. And then the next step would be to conduct a privacy impact assessment or a data protection impact assessment. That's defined under Article 35 of the
Right.
GDPR. So
Yeah.
in this, what we do is we try to conduct an assessment on the basis of the risk. We try to figure out a risk matrix for the specific processing activities that we have figured out from ROPA. So if we talk about GDPR, they have given certain preconditions. If these processing activities are taking place, then we'll conduct a privacy impact assessment, such as if there is a change in technology, or is there any surveillance taking place, or there is a special category of data involved. So in this cases, we conduct an assessment. And finally, the final step would be the implementation part. We have understood all the gaps. We have an inventory in place. We have conducted an assessment. Now, the implementation part would include preparing various policies or documentation, both internal, external. Like we'll have data protection manual, then data breach manual, etc. So this is a general overview of how the compliance takes place and how implementation of privacy takes place.
Okay. So, you have been looking across various jurisdictions. So, well, recently, the ministry has asked the data fiduciaries, as you may be knowing, to start complying with the DPDP Act. So, how do you think are companies going about their compliances?
Okay, okay. Yes, that's correct. That ministry has asked the companies and the organizations to start complying with the DPDP Act. And what we can say is that they would be penalized,
Yeah,
right?
yeah,
So,
correct.
I'll talk about some steps which the companies must undertake so that
Yeah,
they have a basic level of privacy implementation within their organization. So, to start with, as I have mentioned in the previous question as well, we should have a data inventory in place where we should
yeah,
have all the data, personal data attributes that are being collected, the purpose, the legal basis, whether it's consent or legitimate use, as is given under our DPDPA, and what is the category of data, etc. Then we need to also understand we need to map the data flow as to whether like data is flowing from within the organization or it's flowing to some third party, maybe data processor to some other country. So we should know the flow of the data. Then the other thing that's very, very important that organization must do, like right now, before the rules come out, is the consent mechanism. So if I talk about DPDPA, the mechanism, its consent framework, it should be very strict.
yeah,
And just
correct.
like GDPR, they have mentioned that consent should be free,
Yeah,
explicit, specific, informed, and whatnot, which is, I believe, very, very correct also, because it's the personal data of data subjects, and
yeah,
that data belongs to them, so we cannot do it without their
correct.
consent. So, if I take a very small example for understanding the consent mechanism, so let's say there's a company Y, and it's a consumer facing company. They have a website in place, they have an application in place. Okay, so let's talk about their application. So,
Yeah,
once we install their application, so it will ask for various permissions, let's say camera, microphone, messages sometimes, etc. Okay, and so what is necessary here when they'll talk about permissions, when they ask about permission, they should mention as to the reason why do they need, let's say, camera,
yeah,
microphone. What is the use of that? Why they need access to our SMSs? So they need to map out the purpose, and there at the end there should be a checkbox. And mind it that it should not be a pre-ticked checkbox,
yeah,
because there you do not follow the explicit consent clause that is mentioned under our
true.
DPDPA. It should not be pre-ticked, and there should be terms and usage as well as privacy policy attached there, and then the consumer has to tick that option and agree to it. Then it would be
Yeah,
an explicit consent from
true.
the consumer. Then, other than that, there should be a data breach management mechanism in place as to when a data breach takes place. The company or the organization should know when to notify the various authority, be it board, And then we have certain, that's the Indian Computer Emergency Response Team, which need to be informed about the breach within the 6 hours of the breach. Then there, and I think one of the most important step would be training and awareness amongst the employees, because India in general does not actually have a very privacy pro environment. So it's very important that we make them aware of it, so that they can actually respect and adhere to the obligations that are there on the company and the organization.
Uh, so in India, the companies that have been operating in the international spaces, well,
Mhm.
have been complying with GDPR. So, are there any lessons we can learn from the GDPR compliance while complying with DPDA?
Okay. So yes, many organizations have been operating across globe, and so they are required to adhere by the GDPR or maybe any other law for that particular jurisdiction. So I believe any lessons, I would think that what an organization should keep in mind is that the core principle of GDPR, DPDPA, or be it any other data protection laws is the same. It is based on some specific principle which has been collated under Article 5 of GDPR, but there is no explicit article section in our DPDPA, but those principles are there in place. So, like if I talk about the principle of transparency, then data minimization, purpose limitation, integrity, confidentiality. So, if the organization is doing such practices in which they are complying with these basic principles, then they are good to go, I guess.
Okay. So, like you've been working across since you've been working across various jurisdiction. So, you must have seen that how companies approach compliance when they like operate in different jurisdiction, having different data protection laws. If you can elaborate on that.
Right, sure. So if a company or an organization is operating in various jurisdictions, say in India, Europe, and some countries of Middle East, so what they are actually required to do is that they should try to comply with the strictest laws. Because once they are complying with the strictest laws, then they are automatically complying with a little non-stricter law.
Yeah.
Let's take an
Correct.
example. For example, let's for easy understanding, let's take example of GDPR and DPDPA. So we know that GDPR has provided various rights, and if we talk about DPDPA, so we have four major rights given under DPDPA, right? So let's talk about right to data portability. That's there in GDPR, but it's not there in DPDPA. So right to data portability is basically that you should provide the data subject or data principal the right that they can that their data could be transferred in a readable format to another organization, okay, if he wants that, okay.
Yeah.
So
Correct.
we don't have in DPDPA. So the organization or the company should have a mechanism in which they can in which they can actually, if this such a request by data principal comes for data portability, right of data portability, then they can adhere to that right. So if they adhere to the right, then basically they are complying with GDPR, and the common rights like right to access, erasure, deletion, they are common in both the jurisdictions. So they would be automatically fulfilled. So the approach would be to follow the stricter law, and automatically you will be adhering to the other laws.
Right, right. So the data compliance requires funds, right? So like large companies do manage to do that. So like you've been working with various companies. So in your experience, like in India, there are many small companies that don't have a very large budget for data protection compliance, right?
Mhm.
So, what they can do to prevent lapses in spite of their small budget?
Right. It's true that we do require funds for data compliance and all, but it's partially true, actually, I would say that,
Yeah,
like, for example, if we take the example of a small company. So there are various cost-effective strategies that they can incorporate and be compliant with, let's say, DPDPA. So, for example, they can implement the basic security measures. It could include like having strong password policy. Then they could also have two-factor authentication for additional security. They could have access control in place. This, what would happen that if they have access control in places that that the data, they it would not be available to all the employees, let's say employees of the company. There would be some restricted access who have those like access of that data to the people, right? Then the other thing which even a small company can do is to have a data inventory. So you can manually create records of processing activities, I have told you, where you can map out all the data attributes that are being processed by the company, the purpose and everything. This would help you, like when audits takes place, then you have some document in place where you can show that we have documents in place where we have mapped out everything about the life cycle of the data, right?
yeah,
Then finally, the if I talk about data protection policies, so the companies can build data protection policies taking inspiration from we have like various companies which are compliant to it, so they can take inspiration from the policies of theirs, and they can build both an internal as well as external policy. So let's take an example, like if I talk about privacy policy, so they could have like privacy notice in place, which would be for the external consumers, where uh, they should take into consideration that they are mentioning about all the rights which have been given under DPDPA and the legal basis of processing and the general things that should be there in a privacy notice. And then they should also have a privacy policy in place that would be for the internal use, because the employees and
yeah.
of the company, they should also be aware about the data protection policies that are there in their organization for their data as well. Then the last thing I would say is very, very important is employee training. So this would be a one-time investment, but will give you fruits for lifetime, I would say. Because once the employees are made aware about the data protection and privacy compliance, the general if they have general and basic understanding of it, then they would like the company would be good to go with, and they would be complying with the various laws and like the recent one being the DPDP Act. And and if I talk about the funds, like we were mentioning that data compliance do require funds and
Yeah.
all. So if I talk about the additional requirements of audits, assessments, and everything, so if we look at the DPDP Act, they have been mentioned under Section 10. Section 10
Yeah,
talks about
true, correct.
significant data fiduciaries, right? And like the rules are yet to come up, and so we don't know what companies would be coming under data significant data fiduciary. But as per the prerequisite conditions that have been mentioned under the section, it seems that it would be big companies that would be dealing with a lot of data, and like that could affect the sovereignty of the country. So I think they do require some additional compliance, but small companies would be good to go with the steps that I've just mentioned.
Okay. So, with this, I would like to ask you the last question of our podcast, and this is something which we have kept as a staple question for all our
Right.
guests. So, what are the factors that led you to explore the field of tech law? And
Okay.
we're hoping to hear something interesting, not like an internship or something, something interesting.
Right, right, right. So, I would say, like, when I started my law school, like any other law student, I had a bent towards criminal law. It's damn interesting. We should
True,
accept that.
true, true.
Everybody is interested in that. So I was like hoping that I'll build my career in that field only. But honestly, I also looked at the practical side of practicing criminal law in the courts, and I was not very sure about that. Then I explored arbitration. It was booming at that time. I mean, everybody was into
Everybody,
arbitration, everybody. So
everybody.
I tried to gain some interest, but to be honest, I was just kind of adjusting myself in that field because everybody was doing that. But to be honest, I was not. I knew that that's not my interest. And I think by that time I reached my fourth year of by the end of the third year and beginning of fourth year. So I came across this case of Tesla automated vehicles. I mean that the case was going on for a long time, but I came across at that time. Okay, so the problem, the case was related to automated vehicles. So, and at that time also was a series that had come up. I don't remember. It was on Amazon Prime. That was also related to automated vehicles. And let's say if there's an accident caused by an automated vehicle, then what would be who would be liable? Whether it would be the manufacturers of the car, whether it would be the person who has bought the car, or like whom you would make liable, and how the compensation would be paid to the person who has been injured or maybe even come to death. So that was the point which triggered my interest, I would say. And from there on, I have been exploring the various aspect of technology law. I tried to enroll into various certificate course because, to be honest, in India, we still are not in a we have internships and opportunities in tech law,
True,
but
true.
not that much. And specifically in Jamia, there were very, very, very few people who would be following this specific field. So didn't I didn't mm, had anybody to ask about it. So, and from there I enrolled in various certificate course, and from there it has amplified, I would say. I read about various things, and yeah.
So, perfect. So, with this, we have arrived at the end of this episode. So, thank you so much, Dee, again, to take time out of for us, like despite of your prior occupancies, and we wish you luck for your future endeavors. So,
Thank you so much for having me, and I also want to wish you all the very best for this podcast, and I hope that you guys do very great in this field.
thank you so much, Dee.
Thank you so
So,
much.
goodbye to all the viewers until the next episode. And uncertain, you all will find this episode insightful and informative. Thank you.